Let's talk about sellers' reps and warranties. And this is obviously a favorite topic for lawyers. And Section 12.1 of the Purchase and Sale Agreement has a list of areas that are warranted by the seller. I would say this is a healthy list. It's not the most exhaustive list. Obviously, as a buyer's lawyer, you can supplement and expand this to include topics that are applicable to a particular property. But generally, Section 12.1 deals with the authority of the seller, that the seller has the right, power, and authority to enter the contract and consummate the transaction, that the seller will maintain the property pending escrow, the seller is unaware of any hazardous substances, that the seller, to the best of the seller's knowledge, the property complies with all applicable laws. The seller will not change the leases or any other agreements while the property is in escrow, that there are no other leases, there are no mechanic liens, no lawsuits, no tenant bankruptcy, and no lien on the personal property. So what's important to, as a lawyer, ask yourself, are we using the purchase and sale contract that's published by the AIR to try to streamline and accelerate the deal? Or is this just a starting point to start heavily negotiating? And I've seen both, and I'm sure everybody in the audience has seen where you start with a printed document, and then it gets ripped to shreds, and the addendum is much longer than the actual contract. So what the AIR has done is try to provide a set of warranties that if a buyer was represented by competent real estate counsel would get from a seller who was represented by a competent real estate counsel. Is it everything that a buyer would ask for? No. Does this mean that the seller has to agree to all of this? No. But here's the reality of how this plays out when you go to negotiate. Once you strike or modify one of these, inevitably, either the lawyer for the other side or the principal of the other side will look at what you changed or what you added. And that becomes the bone of contention. And while there's no standard for what is a usual set of reps and warranties, these warranties have stood the test of time for many years to be good enough for a buyer and a seller. It's not too much to the landlord, not too much in favor of the buyer, not too much in favor of the seller. So the contract provides that the warranties survive for 3 years after the closing. Obviously, this is not the law in California, which is 4 years for breach of contract, but it's there as a placeholder to remind you that if you want to modify, and this is something that gets negotiated in attorney-negotiated purchase and sale agreements, how long is the seller's warranty going to be good for? So it's there. If you want to modify it, you could reduce 3 years to 6 months, or you want to lengthen it you can do that too. From the seller's perspective, you want to reduce the duration of seller's warranties. And from the seller's perspective, you want to eliminate as many as possible to reduce the seller's exposure for having made these representations and warranties.
Bryan, this may be a good place for the question we have in the Q&A, which is, do you routinely see buyer's counsel use a very custom form of agreement, especially maybe on deals that are 10 million and above? And then if you represent the seller, do you try to convince counsel for the buyer to use the AIR form, and why or why not?
For larger deals and more complicated deals, I see the tailor-made contracts being used more often. But I myself have done many what I consider to be large leases and purchase and sale transactions using the AIR contracts. They work just fine. And they actually help limit the negotiations between the lawyers by giving you the basic framework of an agreement. And you focus on what specifically needs to happen in this particular deal. So for larger transactions, I think sometimes parties want to have document control, Howard. They want to assert their leverage, especially in today's market where it's a buyer's market. So I've seen pre-printed contracts like the AIR used, for example, by somebody who puts an addendum on it that becomes so onerous that they might as well use the tailor-made contract, that it wouldn't have made a difference. So if you're going to go use the AIR contracts, try to stick with what the point of it is to streamline and to streamline the transaction and avoid a lot of unnecessary negotiating. But again, that's a question of market, who's got the leverage, and who wants to deal more badly, right?
I think one other big benefit of using the AR form agreement is because if real estate lawyers tend to be familiar with them, some of the buyers and sellers are familiar with them, and you know where to find particular points. Whereas even if there's a long addendum, hopefully the addendum relates to the specific point and heading that was in the AIR contract, so you know where to find things. Because otherwise, if you have a custom agreement that's really long, you may not remember where something is in that agreement when you go back to try to deal with it.
Right. If you use a custom agreement, the one who prepared it and is their form has the upper hand. They have so much more information about the contract that it gives them a real leg up in the negotiation. And using the pre-printed AIR contract does sort of even out that playing field. So it's not completely lopsided like it is when you start with the other side's form. And I've seen it where sometimes it actually doesn't help to use a pre-printed form where it gets so heavily negotiated, then it becomes kind of clunky negotiating the contract. So sometimes it may make sense not to use it and just go to a tailor-made one. But if you're going to use the pre-printed, try to not to just undermine the whole purpose of it by having a lot of changes or a huge addendum.
And make certain that the changes relate to the section in the AR contract that already addresses the subject matter, so it doesn't get too confusing to find.
Right. So in the AIR contract, quite a few of the representations and warranties are limited to the seller's knowledge, and it's very commonplace to have a seller define seller's knowledge to be the actual knowledge of a particular identified person who works in the seller's organization. So, and that duty, that knowledge is without any duty of inquiry or investigation. So it's what that person actually knows at the time the contract is signed. And this is a typical ad that I see, and I don't think it's unfair for a seller to add this. It also disclaims the knowledge of sellers, other agents, and employees or principals. This provision also typically says that the person who's named in the contract doesn't have any personal liability if it turns out that the warranty was breached. Rather, it's the selling entity that's going to be on the hook, not the individual. One thing to pay attention to is section 12.3 provides that if the buyer closes after the buyer has learned the rep or warranty is incorrect, that equates to a waiver of the seller's breach. Now, in California, there's a split of authority on this issue of whether or not a buyer waives a breach of warranty by proceeding to close or not. And I think as a buyer, you may want to be able to sue and not be deemed to have waived the breach of a warranty, so you can recover damages that may be due because of the misrepresentation or the misleading of the buyer to enter into the contract, and then the buyer was stuck in a bad position where they had to close the deal, or they would end up suffering significant damages. So 12.3 is something that as a buyer, it protects the buyer. As a seller, you may want to flip it and till there's some kind of a resolution of the split of authority in California. Our contract says it's a waiver, which is more in line with what a ordinary person would expect, that if you knew a rep or warranty was incorrect and you bought, then you assume that risk.